Another part of my practice is sexual battery cases, and those are usually distinguished into my clients who walk into a third party establishment they have no relation to and they're sexually assaulted by someone who works there, or a client who works for an employer and they're sexually assaulted during the course of their employment. Now, a lot of people think that if you're sexually assaulted or harassed in the course of your employment, then your only remedy is to file a claim with the EEOC and go through federal court and get it adjudicated that way. However, Georgia has a statute, the negligent retention statute, which effectively covers these types of claims if you can show that an employer knew or should have known that an employee engaged in the type of behavior in which occurred in your incident. So, for example, if an employer knew or should have known that a certain employee enjoyed groping women's private parts or other offensive behavior, and that employee does the same thing to you, then the employer, could be held liable for that employee's behavior. Again, if they knew or they should have known. So they don't even have to just know about it. If the facts indicate that they should have known that this employee was capable of such action, then again, they could be liable. But you have to prove that you did endure mental pain and suffering as a result of it, and there has to be some sort of physical harm, although under Georgia law, when there's a battery, there is an assumption that a physical harm occurred. So again, if you feel that you've been sexually assaulted or battered either in a private establishment or at your place of employment, give me a call, 404-975-0958. I'd be happy to discuss it with you and advise you of your rights.